What? Let us see when the matter reaches. Mr. Mojumdar, I know how to deal with this matter. I fixed this matter along with it when the other side is there. We have to see that the order which has been passed by this court is complied with. Okay? If you want to withdraw, withdraw. You want to withdraw? Don't withdraw. Ah, don't withdraw. We'll see when the matter reaches. We'll, we'll reject your prayer because of the fact that I don't allow this type of mentioning at this hour. Not granted. Rejected. What is this? You are filing an affidavit today. We'll see when the affidavit comes before us. Call for that. If you don't file, you know the consequences which may befall upon you. So I'm not granting you an adjournment. এইখন ডাঙৰ এখন লিখি দিবচোন। For affidavit filing, no adjournments mentioning. Every time I keep on telling this. Tomorrow? Monday? Absolutely no. Why have you all come up with certain prayers which is not possible? Why Tuesday? The senior may not like to do on Tuesdays. It is not possible. We can have it on a Tuesday during the vacation. Let's take it up on a vacation court. 7th of July. Okay? Don't mention. Mention rejected. Next. What is this? What is the direction? There is a direction to for what? What is, why the contempt? So it has been decided to be done within 45 days from today. 45 days is over. So direction to whom? Who is the government? Get hold of Mr. S. Dotto, will find out. মাতিব ন কোনটো S. Dotto আহিব ন? কি নাই? Issue notice making it returnable on 27/2026. Steps be taken upon the respondent by way of speed post. In addition to that, petitioner granted liberty to take steps by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner herein has filed the instant application alleging willful and deliberate violation to the order dated 16/5/2025, passed in WPC number 1 with petition. The one petition. Which one? 3427/2024. Whereby the learned coordinate bench of this court had directed that the respondents in the respondent authorities would have to pay to the petitioner his bills for the use of his dumpers at the rate of rupees 11,400 per day. And the bills of the petitioner should be paid within a period of 2 months from the date of receipt of the certified copy of the order. The record further reveals that on 21/5/2025, the office of the contemner duly received the certified copy of the order dated 16/5/2025. It is alleged that in spite of receipt of the certified copy of the order, no payment has been made to the petitioner. You have not got money. How much? I've only paid a part payment of the dues of the petitioner, but the entire amount had not been paid. It is under such circumstances the present application has been filed. So, taking into account the allegations made at paragraph number 5, 6, of the instant application, this court is of the prima facie opinion that a case for initiation of contempt proceedings arises against the respondent oblique contemner. The respondent contemner is therefore directed to show cause as to why contempt proceedings should not be initiated against him by filing an affidavit on or before 15th of July 2026. You get the money? You have not been paid. Not a single penny. Issue notice. Why you are making the state of Assam a party? Okay. Issue notice upon the contemner. Returnable on 27/2026. First, the petition to service by steps by speed post or dusty. Agad Dibode, dusty should be effected on or before 8th of June. Agad, huh? 8th. The petitioner has filed the instant application alleging willful and deliberate violation to the order dated 29/8/2025, passed in WPC number 2682/2025, wherein there was a direction upon the respondent authorities and more particularly to the contemner to verify the claim of the petitioner within a period of 1 month from the date of the said order, and in the event the claim of the petitioner was found admitted, the same be released within another period of 2 months thereafter. It is alleged in the instant application that in spite of the fact that a certified copy of the said order was served upon the contemner on 2/9/2025, neither the petitioner has been informed about the rejection of the petitioner's claim, nor any payment have been made, though more than 3 months have already passed. From the above perusal, from the allegations so made in the instant application, this court prima facie is of the opinion that the order dated 29/8/2025 passed in so and so have not been complied with. Under such circumstances, this court therefore grants an opportunity to the show cause, directs the respondent oblique contemner to show cause as to why the contempt proceeding should not be initiated against him for willful and deliberate violation to the order dated 29/8/2025, passed in WPC number so and so. The contemner oblique respondent is given the liberty to file their response on or before 15th of July 2026. Many contempt applications. Why? What is the case? So you have not got the money. In spite of directions. Now, what is this document at page 21? Huh? This is being written by AIA to the Additional Chief Secretary, Revenue, that you are entitled to 30,77,930 and the amount has not been paid. Now, you have filed a contempt against whom? We are not issuing notice upon two. We issue upon this L. Sweetie Sangang, IS. Okay. Because he has done his bit. I'm not on that. You see, the district commissioner has done his bit. That he has said with reference to the so and so, so and so, so and so, regarding release of fund to the petitioner for the supply of remand within a period of 4 months from the date of the order. So this amount of 30 lakhs, therefore you are requested to arrange the release of the fund to clear the liabilities as per the order of so and so. We issue notice, but ask only one to show cause. Issue notice making it returnable on 27th of July 2026. এইকেইটা আগৰ নিচিনা লিখি দিব ষ্টেপছটো এনেকে কৰিব স্পীড পোষ্ট আৰু ইয়া The present application has been filed alleging willful and deliberate violation to the order dated to the judgment and order dated 23/7/2025 passed in WPC number 6828/2024 whereby this court had directed the respondents to verify and thereupon make payment to the petitioner within a period of 6 months from the date a certified copy of the order was served upon the Principal Secretary to the Government of Assam Revenue and Disaster Management Department. In consonance to that, in pursuance to the said directions, the petitioner served the certified copy of the order upon both the respondents oblique contemners, as would be apparent from annexure B and C to the incident application. This court have also taken note of that on 6th of October 2025, the respondent number 2 have written a letter to the Additional Chief Secretary to the Government of Assam. Bracketed diba. Earlier designated as the Principal Secretary to the Revenue and Disaster Management Department. Bracket close. Informing that the petitioner is, upon verification, has been found to be entitled to rupees 30,77,930 and therefore requested for arranging the necessary funds to clear the liabilities. First, however, on account of the liabilities, on account of funds being not available, not being provided, the respondent number 2 have not yet been able to disburse the amount to the petitioner. The above act on the part of the respondent number 1 therefore prima facie shows that there is prima facie the above inaction on the part of the respondent oblique contemner number 1 prima facie appears to be contrary to the directions passed by this court. Under such circumstances, this court directs the respondent number 1 to show cause as to why contempt proceedings should not be initiated against her. for willful and deliberate violation to the order dated so-and-so, passed in so-and-so. The show cause to be filed by the respondent number oblique contemnant number one. The respondent oblique contemnant number one shall file, is granted the liberty to file the show cause on or before 27/2026. You take service by Dusty also, huh? Things will. Hey, human contempt. What is this? Issue notice returnable on 27/9/7/2026. Take any steps to speed post as well as Dusty, huh? And effect service on or before 8th of June by Dusty. That will be written. See the order when you are taking steps. Okay? This is an application filed alleging willful and deliberate violation to the order, judgment and order dated 22/8/2025, passed in WPC number 4170/2024, whereby this court had directed the respondents in the writ petition to make payment of an amount of rupees 9,50,000 to the petitioner after making such statutory deductions if so required within a period of 6 months from the date a certified copy of the order judgment was served upon the Joint Director Health Services, Karbi Anglong Autonomous Council District, Autonomous Council. The record reveals what? Upon the Karbi Anglong Autonomous Karbi Anglong Autonomous Council. You have mentioned this. Joint Director Health Service, Karbi Anglong Autonomous Council. That is the response number 5. In pursuance thereto, the petitioner submitted the certified copy of the said judgment and order dated so and so on 30/8/2026-25, which was duly received by the Joint Director of Health Service, Karbi Anglong, on 1/9/2025. It is the case of the petitioner that though the amount was duly admitted and as such directions were passed to make payment within a period of 6 months, but even after the passage of 6 months being over, no payment had been made, and it is under such circumstances the petitioner has approached this court by filing the present contempt application. From a perusal of the allegations made in the contempt application, as well as the directions so passed by this court in the order dated so and so, judgment and order dated so and so in WPC number so and so, this court prima facie is of the opinion that the action on the part of the respondent in not making payment to the petitioner, not disbursing the amount to the petitioner, appears to be contrary to the directions so passed. First, under such circumstances, this court directs the respondent oblique contemner to show cause as to why contempt proceedings should not be initiated against the respondent oblique contemner. The respondent contemner is granted the liberty to file the reply on or before itu আগৰ to good. None appears for the petitioner. Who is he? What is the matter about? Cow. She's This is the second time the petitioner is not represented when the matter has been called. It appears the petitioner is not interested to pursue with the instant proceedings, for which the instant application stands dismissed for non-prosecution. Ms. So-and-so appears on behalf of the respondent. Why should we entertain this type of matters? 1991, madam, it is, why are you, no, this type of admission would not work. Go to the civil court, you have the admission out there. This court is not going to entertain a claim of 1991 today. Absolutely no. Will you dismiss your petition? Sorry. I'm not going to allow this type of petition. Why should we allow this type of petition? 1991 you claim. What is wrong? The judgment you are referring to Annexure 8? That judge who passed that order have become a judge in the High Court, then Supreme Court, he has retired, then now you are coming before this court. Isn't it? So, we dismiss it. I'm not going to issue notice in this type of matters. What do you say, Mr. Bora? We should dismiss it with cost also upon the lawyer for encouraging this type of litigations. Lekhok. Heard Miss So-and-so, the learned senior counsel, assisted by So-and-so, appearing on behalf of the petitioner. Mr. D.P. Bora appears on behalf of the Health and Family Welfare Department. Mr. So-and-so appears on behalf of the Finance Department. The present petition has been filed by the petitioner, claiming an amount of rupees 24,255, which was due to the petitioner in the year 1991 from the respondent numbers 2 and 3. First, it is the case of the petitioner that the various respondents that the petitioner have been pursuing the said claim since 1991 till 2025, and having not been successful, the present petition has been filed. Full stop. This court have perused the materials and as the claim of the petitioner arose sometime in the year 1991, mere filing of representations for the last 34 years cannot be said that the petitioner has been diligent. Full stop. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in so and so a Kumbhakarna judgment. Taking into account the above, this court is therefore not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. এটা তলত লগাই দিব, needless to mention that সেইটো আমি যে এটা এইবোৰ ডিলেবোৰত এটা লগাই দিওঁ না, ক'ত যদি ফাইল কৰিব পাৰে. Yes, Mr. Doctor, what is this? You have been, because you see, it is your duty. The court has imposed the duty. Have you made Mr. Doctor also a party? Huh? No, no. Because you see, otherwise I would not have called. Paragraph 15 says, a copy of this order is to be supplied to Mr. Datta, who will communicate the same to the government in the so and immediately to facilitate and expeditious. He is responsible. This is an application filed by the petitioner alleging willful and deliberate violation to the order dated 18/2/2026, passed in WPC number 885/2026. For the purpose of convenience, this court finds it relevant to take note of the directions which were passed by the learned coordinate bench in the said order. Paragraph number 13, 14, and 15 of the said order, being relevant, is reproduced hereinunder. From a perusal, page 17 of Prabhupada. From a perusal of the above directions, it is apparent that the learned coordinate bench of this court directed the government, state government, to take a decision by giving an opportunity of hearing and such decision be taken as expeditiously as possible and preferably within a period of 45 days from today. It is also seen that a copy of the order was also it is also seen that this court, the learned coordinate bench, had directed that a copy of the order be furnished to Mr. S. Dottor, the learned standing counsel of the PNRD, so that the respondent state, so that the PNRD department could facilitate an expeditious resolution of the dispute. However, as no steps in that regard have been taken, the petitioner has approached this court. This court requests Mr. S. Dottor, the learned standing counsel of the PNRD, to apprise this court as to why till date, as to whether the allegations made in the instant application are true. And if so, why till date no action has been taken? A copy of the instant contempt application be furnished to Mr. S. Dottor, the learned standing counsel of the PNRD, for taking steps as directed above. List this matter again on 12th of June 2026 for an update. The registry shall show the name of Mr. S. Dottor in the cause list. S. Dottor, standing counsel, PNRD. What is this? Oh, Mr. Deka, what is this? So nowadays we only have fishery matters, huh? The different type of writ petition you have made. Huh? Oh, this is the plaint. There's a suit pending. Against? So that suit is pending. Therefore, I was seeing the prayer out there. Yeah. So what are you challenging? Giving effect to the impugned settlement dated 7/5/2026. So that settlement order was not with you, which you brought in by way of here. Now, what is your ground? 40. Ah, then you are the second highest. How much have you quoted? You know how much you have quoted. So you don't know. How are you saying that you are the second highest? Because I know what he has quoted. So I am clever in that. But therefore, you tell me how much you have quoted to say that you are the second highest of the. Yes. Where? What does it say? Were you a bidder? There's 4 crore 10 lakhs. You're a bidder. Why the settlement order? There must be a minutes. Where is the minutes? Okay. Certain bidders submitted so and so it is observed that have they taken into consideration pertains to particular the requirements of the government fishery dated so and so pertains to pension AI issued by the company and not an AI, and therefore the objection raised on such grounds are not tenable. Further, the request for withdrawal of the bid submitted by an individual. Now, how did they later on fulfill it? My question is, how did they later on, because only certificate which was not given was of the plaintiff in that suit. No, no, that is, no, kindly see this document which you have read to me. Kindly see. Here, the remaining one number of caste certificate in respect of so and so current vice president of the society has not been submitted up to this date. Now, therefore, the question is, to be 100% fisherman, this person concerned was satisfied with the 14. My question is whether the 15 number was uh, belonged to the fisherman. My friends, no case dismissed. That no, it is mandatory. Therefore, I'm saying when it is mandatory, I'm therefore saying your entire case hinges on the document dated 23rd of March 2026. FIR who has filed? Maybe. So you are now filing the instant requisition by putting the gun, or your soldier is now being used by Rajeshwar Bora to fire the gun, isn't it? So it is the other way around. It's the other way around. Means Rajeshwar Bora is taking all these steps at the instance of the petitioner. So he's putting the soldier is of Rajeshwar Bora. No, no. My therefore question is to Mr. Dekar, whether on the basis of the certificate of Mr. Rajeshwar Bora at a later point of time, do they constitute the 100% fisher? Why? No, Mr. Dekar, my question is this. Your basic case is on this document of 23/3/2026, wherein it says that there was a direction being issued to this particular society. That look here, you produce the certificates of the 15 directors. 9 certificates have been produced. 8 certificates have been produced. The other 6 have been also produced. He doesn't say anything on that. This order is based upon non-production of Rajeshwar Bora's certificate. Rajeshwar Bora, na? Rajeshwar Bora's certificate. And therefore, this order has come. My question is whether Rajeshwar Bora is an SC or the fisherman. Now, whether the caste certificate which have been issued to him have been declared by any authority which is required under law for cancellation, have they done it? He has said that, but has he proved it in the suit? You have made the mistake of filing a suit. That suit has to come to an end. In fact, your suit, which is you have filed, your the person on whose soldier you are filing has filed. Rajeshwar Bora had filed. Rajeshwar Bora has filed. So Rajeshwar Bora, in his suit, he's claiming certain things. Now that suit has to be decreed. Once you decree, then you come. Show me that. Show me that. Which is the document to show? Vera, show me the document. Let us see the impugn order. Impugn order duly takes note of, kindly come to page 69. It is further observed that certain complaint petitions have been received from different parties in the connection with the tender process. After careful examination, it is found that the issue raised in the such petition either pertains to bidders who are directly already technically disqualified on account of non-compliance with the mandatory tender conditions or relate to matters not relevant under the applicable rules. In particular, the requirement under the government notification dated pertains to submission of an actual fisherman's certificate issued by the competent authority and need not individual caste certificate. Now, did he submit the actual fisherman's certificate or not? So therefore, if he had submitted the actual, unless that certificate is not cancelled in a process, no, kindly see here. He should and not individually, and therefore the objection raised on such are not tenable. Further, the request for here. Further to that, further pursuant to the queries raised during the examination, a clarification was obtained regarding the of the Vice President of Sri Lanka seeking withdrawal of the bid. On verification, Sri reported that had duly adopted whether to participate in the bid. It is pertinent to note that the previous lease period of the lease expired on so and so, so and so. Then, so the only question, no, Mr. Dekka, only question is, did they submit the actual Fishermen Society certificate? That is the only question. We are having a 7-year period. You have 7 years to fight out the litigation. Okay, we'll let us issue notice. So only therefore the issue is as to whether they submitted the actual fisherman certificate. No, only that. Nothing more. Because that is otherwise also the mandate as per 18/1/2026. 16 or 26. 2018, that is the requirement. Actual fisherman certificate. Did the respondent number 7 submit that? Simple issue. Once that is being submitted, others gone for a 6. We cull down this into a very short litigation. We finish it up next week. Not next week, next to next week. Huh? So therefore, did you submit the actual fisherman certificate or not? So did you submit your certificate or not? Matter, that is the only thing. So limited to that. Huh? It's okay. I'm not interfering with that. Only thing is this. Issue notice making it returnable on 10th of June 2026. Mr. Mr. P. Sharma accepts notice on behalf of the respondent number 125. And why you are making number 8? Now, who has got it? Only 7 has got it. Why you are making number 8? Okay, we strike out. Okay. You are third. Oh, he did not say the word valid earlier, na? Okay. It appears on behalf of respondent number 1, 2, 5. 4 also? 4? 4, 4. Okay. 5, 5, 1, 2, and 5. Mr. Vodlo appears on behalf of respondent number 6. So and so, Ms. Udas appears on behalf of the respondent number 3 and 4. Mr. M.K. Chaudhary, the learned senior counsel, assisted by Mr. You are appearing. As count appears on behalf of the respondent number 7. Understood. Extra copies of the writ petition be served upon the learned counsels appearing on behalf of the respondent numbers 1 to 7. 1 to 7. This court, however, for the present is not inclined to issue notice upon the respondent number 8. The present writ petition has been filed challenging the order of settlement dated 7/5/2026 of the number 3 capital A lower part Brahmaputra river fishery under Kamrup district. The sole ground on which the settlement made in favor of the respondent number 7 have been challenged is on the ground that the respondent number 7 did not submit the actual fisherman's certificate, which is an actual 100% fisherman's certificate, na? 100% fisherman's certificate. Actual fisherman's certificate or 100% fisherman? Actual 100% fisherman's certificate issued by the competent authority along with their bid, which is otherwise the requirement in terms with the notification dated 18/1/2018, as well as Rule 12 of the fishery rules. In that view of the matter, it is the opinion of this court that the said aspect can be seen from the records. Mr. P. Sharma shall produce the records on the next date. The real records in original on the next. You have records? The records which you are having, because normally sometimes I've got only photocopy. I don't have the original. I'm not concerned. The records shall produce the records which were taken into consideration by the authorities concerned for passing the order dated 7/5/2026 on the next day. I have not saying later on. I'm therefore saying the records which were taken into consideration for passing the order. It includes many things. What? Now we'll see you on that day. In the meantime, the respondent, and the private respondent number 7 is granted the liberty to bring on record its stand by filing the affidavit on or before 4th of June 2026. KVS stands discharged. What is this? You want a license or a renewal? Fresh license. When did you apply? 10/1/2024. Until date, they have not given you. Why do you need the license? Huh? When? 23. You lodged an FIR. Where is the FIR? Then what happened to that case? What happened to that case? So one phone call, you apply for a license. So what? Every businessman should have a gun. Tell me. I don't think this is a fit case. What do you say? Should I issue notice? Not a fit case. What happened? He should be more diligent. For last 3 years, what has happened? You don't know anything. Why shouldn't we issue notice in these type of matters? Huh? What is this? Oh, you are in some here. What business are you? Okay, Lehok, issue notice making it returnable on 15th of June 2026. Mr. S.R. Borua accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the petition be furnished during the course of the day. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in considering the application filed by the petitioner for Grant of an arm license dated 10/1/2024. Full stop. The Learned Counsel for petitioner further submitted that the Superintendent of Police, Dibrugarh, had conducted verification on 25/1/2024 and also had submitted a favorable report in favor of the petitioner. And then also, the concerned authorities have not issued the arms license to the petitioner. It is under such circumstances the petitioner had approached this court. The respondents herein are directed to bring on record the stand as to why, till date, the petitioner's application for grant of a license, which was filed on 10/1/2024, have not yet been considered. The affidavit be filed on or before 12th of June 2026. Mr. Rathi, yes. What is this now? Where? Which circular? Dynamic pricing freight business. A 2006 circular you are challenging in 2006, you are challenging in 2026. What is the reason behind? Now you are challenging which one? So where is the impugned circular? 748. Yes. Why are you challenging here? Let me dismiss this, then you both together into the. On the Railways Act. Let me dismiss it. So this we dismiss it, so the matter goes there. Eh? Under which section you are saying? 199 of? Yes, rules to be laid before the parliament. This is rules. Every rule made under this act shall be laid as soon as may be after it is made before the House of the Parliament while it is in session for a period of 30 days, which may be comprised in one session or in two sessions, and if before the expiry of session be following the session or so and so, both houses agree in making any modification in the rule or the house, or both houses agree that the rule should not be made, the rule shall thereafter be have only effect only in such modified form or no effect. So this is not being done under that. This is being done under some executive power. Show me that it is the no, Mister. Tell me, is the railway board not empowered under Rule 6, Section 6 or something? So. Yeah, this is being done by the railway board. So there is one provision by which the central government's power, 30, na? Remember that. They'll be this. Power to fix rates. The central government may from time to time by general or special order fix for the carriage of passengers and goods rates for the whole or any part of the railways, and different rates may be fixed for different classes of goods and specify in such demand. The central government may by order fix rates of any other charges incidental to or connected with such carriage, including demurrage, wharf rates for the whole or any part of the railways, and specify in the order the conditions subject to which such rates shall apply. So, this is how it is being done. The power is already given. Fixed rates may from time to time by general fix for carriage or so and so. Fix means to impose. They dismiss. This is a dismiss with cost. Na? You do one thing. No, I will ask the division bench also to look into this and then dismiss his petition. Or you file a writ appeal, then it will automatically become connected. Very good. Chalo, egon dio. This is a matter. See, you have not, Mr. Gupta may not have been aware on that date of this provision. See, Allahabad High Court has dismissed, Karnataka High Court has dismissed, Para, Allahabad High Court, 3-5. 5 is the prayer, 8, 9. 9 is where? Learned Council for the Railways refuting the submission of the Learned Council they have submitted. The Railway Board has jurisdiction to fix the rates to the extent of 6 times of the normal rate in exercise of Section 32. And the petitioner has remedy of filing an appeal against the order of penal demurrage on there. In the instant case, demurrage charges have been increased only 2 or 3 times. Other payment. Demurrage so and so have been levied by the railway there within 48 hours. Council so and so. The object and purpose of fixing rates for demurrage charges as laid down by the apex court in the above is regarding C2. which is clearly applicable in the case of railway station where there is a necessity of air use. The phrase fix the rate of any other so and so incidental to or connected with such service. Thus, in addition to fixing rates for demurrage and workers, central government is fully empowered to fix rates of any other charge incidental or connected therewith. The penal rates connected with so and so thus can be statutorily fixed. Thus, the mere fact that the progressively increasing demurrage charge to the maximum of 6 times are also referred to. Section 30 of the Act is similar to Section 29 of the Act of Union Export and so and so held. Other payments made in so and Section 3 fully covered. Penal charges as so and so. Children may by general specific fixed maximum and minimum rates for whole or so and so. Just one thing, Mr. Gogoi, tell me, this is the power to fix, I understand. They can very well fix the rates. And what is the power to impose? Where is the power to impose? No, 30 is fixing. A power, just for example, demurrage charge. They have the power to fix the rates, meaning thereby this power, which is rate, which is actually reserved for the legislature, is being delegated by Section 30 statutorily upon the state, upon the government. But then also the power to impose must be there because they have referred to goods, rates, and so and so. The power to impose must be somewhere there. This is fixation and layer. Where is the power to impose? Power? Where is the power? 32. Power to railways to charge certain rates. Both the rate. No, that is okay. This is charge. No, the Act will 100% mention about the power of tax. Prohibition against so and so, power to refuse, power to, yeah. Now, what Mr. Rathi is saying, I'm not convinced with that. That I'm not convinced. But the 100% the power is there somewhere. Even you can make this power is a power which is being conferred. Just for example, the power to collect, power to impose, or you see, therefore that day I was taking up a interesting matter on a GST. Power to impose and power to determine, power to adjudicate, and power to recovery are three aspects. Here you have to understand the power to impose. You have to go back to, as it is the railways, you have to go to the Schedule 1, first list 1 of the union list. So that power is being given there. Now, once you are doing it for the purpose of regulation out there or whatever, or running these machineries and all, you are doing it, that power is given from there. And this power then transcribes into the Railways Act. The Railway Act will specify the power and thereupon the power to fix the rates at which it is to be done, because the legislature cannot conceive of what are the rates. So the power to fixing the rates, it is absolutely within 30, it has to be done by them. So there will be some power. Power to measure, unclaimed consignment, right? Maybe. You find it here. Or will be there somewhere. Ah, I think 32 will come in. 32 will be there, I think. Power railway, notwithstanding anything contained, a railway administrator may, in respect of a carriage or any commodity and subject of the ER quote, specify quote a station to station, increase or reduce, cancel or so and so, withdraw, alter or amend conditions attached to a station, charge any lump sum rate. So this is the power has been given. So the power is given to the central government to levy. And the central government also has been given the power to fix. And he is agreed with the fixing. No case. No. You may go into the question of the power to fix rates is there, but it is being delegated by the delegated to the state. Now, the delegation may be excessive delegation without quantifying or holding the parameters within which how much the amount can be done. The maximum having not been identified, there are many judgments of that. That is on the question of you may have to challenge section 30 for that. Excessive delegation. You see, the power to charge is already there. Power to fix is also there. But it is unbridled power, means they may fix any rate. You may go on the question of excessive delegation. But for that, you have to challenge section 30. Not yet. Huh? The new charge, no, it is not a new charge. They can charge many, they have been given the power to charge. New charge, whatever charge or any other matter they have been charged. You can identify from section 30 itself by general or whether fixed for the carriage of air and goods rates for the whole or any part, and different rates may be fixed for different classes of goods and specify in such other order the conditions here. So may by a like order fix the rates or any other charge incidental to or connected with the carriage. It is too, this is, it is too broad. They may do many things. The central government has been empowered. So you have to challenge Section 30. And without the challenge to the Section 30, you cannot challenge this notification. Hmm? The 36 is complaint against the railway administration. No, this is an administration. Uh, this will be per se an action being taken by the railways. But he is now on the source. So the power is there. The power has been given, which can be seen from Section 30 itself. The power to fix rates and do all these things. That is, may like order fix rates of any other charges incidental to or connected with so and so. So this power is reserved. Now the question is, it may be this power may be unbridled. It is excessive. So you need to challenge this before the division bench by challenging Section 30. You cannot challenge this document without a challenge to Section 30. What to do now? No, this is, you see, the power which is being given is fix the rate of any other charge incidental to or connected with such carriage. So therefore, you have to challenge 32. Section 30, subsection 2, without a challenge to that the power which has been given is unbridled. It is excessive. You see, the delegation which you have given is too high. You can't give such a huge delegation. There are many 1972, 73 judgments are there on delegated legislation. See that. But not on the basis of this has to be placed here, not good. Make out your case better, not this way. This piece. Withdraw with liberty. And then take it before go to the registry. Registry may take it. Not this way. But this I'm going to dismiss it in this manner. Well, let us dismiss. Let me come back in this. You just give you 5 minutes. And what does the Karnataka judgment say? Huh? Fixation of tariff by the RIA for carriage of goods in the complex fiscal area. That's a different thing. But it is not his case. This is not the case. Where? No. Here it is being done under what provision? This is the busy season charge. So there is a 2006 notification. This is done in 2006. There also, earlier the name was freight business. Now it has become busy season. So this has been done all along. Not new charge, it has been done. Yeah. Is there? Power has been given, not only the power has been given to the railways, but the power is also being given to fix also. So let me come back and dismiss this. Well, after you withdraw it, challenge section 30 as well as this notification. That is the better way. Then, because you have a case for excessive delegation. The legislature, whenever the legislature fixes a rate, there are various laws on that. It cannot be excessive. There has to be certain things, excessive delegation on that aspect. You know. Challenge section 30 as well as these notifications. If section 30 goes, or it says that it is excessive, then obviously the other things will go. But if I dismiss this petition, then for not challenging section, you cannot come again and challenge it. Res judicata will apply. Better. There are many judgments on that line. Go on that. Because if you see, normally what happens whenever the rates are being given the power, it also says that it may not extend to this. Just for example, let us take the case of GST. The state has the power, the GST Council has the power to recommend, but it cannot go more than 28%. It's fixed. It may be 28, 18, 15, 5, 6, which are the different rates which are given, or even 0. And taxing said statutes you will find in others, that and all, everywhere you will find rates are being given by the state, by the legislature itself. Here, the executive has been empowered to fix any rate. You may have to challenge section 13. Mr. D. Rathi, the learned counsel appearing, which one? One is Divyang, other is Divyam. Divya brother. Okay. Mr. D. Rathi, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to challenge Section 30 of the Railways Act 1989, along with these notifications, along with these circulars and notifications which have been impugned in the instant proceedings. He therefore submits that he would therefore challenge the virus of Section 30 of the Railways Act 1989, along with these impugned notifications of the circulars. He therefore submits that he may be permitted to withdraw the instant writ petition without prejudice to challenge Section 30 of the Railways Act, along with the impugned notifications and circulars. Taking into account the said submission, this court closes the instant writ petition on withdrawal. It is observed that the withdrawal of the instant writ petition shall not prejudice the petitioner to assail Section 30 of the Railways Act 1989, challenge the virus of Section 30 of the Railways Act 1989, along with the impugned notifications, if so advised. Mr. K. Gowai appears on behalf. Yes, Mr. Raman. Where's the settlement order? So what do you want? Yes, Mr. P. Sharma. Oh, that must be the reason why. In view of that letter which has been written by the Fishery Department, one letter has been written by the Chief, Additional Chief Secretary or whatever may be, that now all these things have to be done in terms with the directions passed by the Supreme Court in that judgment. Where's the communication? Now, who is running this fishery? Nobody. Fishery Department has a lot of money, I suppose. Yeah. Aren't they? Huh? Smoothly, without even the settlement being made. Yeah? Or is it that you have given to the earlier bidder for time being? Then why haven't you settled for almost a year? Okay, issue notice making it returnable on 10th of June 2026. Mr. P. Sharma accepts notice on behalf of the respondent number 1. Mr. So-and-so accepts notice on behalf of the respondent number 2. Extra copies of the petition be furnished to the respective councils during the course of the day. First, the respondent number 2 had invited a tender, had invited applications from, had issued a notice inviting tender for settlement of 141/142 number Boroli Mari Sitalmari Min Mohol bracket 60% fishery for a period of 7 years by the notice inviting tender dated 4/6/2025, fixing 20/6/2025 as the last date for submission of the tender. The petitioner was one of the bidder. The grievance of the petitioner herein is after the entire process of the tender process being initiated, and the petitioner was found to be the second, the valid highest bidder. The settlement have not been granted to the petitioner. And it is under such circumstances the present petition has been filed. The respondents, more particularly the respondents herein, are directed to apprise this court by way of instructions as to why the settlement in respect to a fishery to number so and so have not yet been brought to a logical conclusion on pursuant to the notice inviting tender dated 4/6/2025. Let's say on the next day. Mr. Sharma, you are appearing for the petitioner. We vacate that order. Order complied with. When did you pay? 18/5. You have paid. So that you should have said in the morning. Now you have. So therefore we close this contempt. The instant application heard Mr. F.Z. Majumdar, the learned counsel, appearing on behalf of the petitioner, and Mr. Mr. M. Sharma appears on behalf of the respondent. The present application has been filed alleging willful and deliberate violation to the order dated 23/3/2026 passed in IA Civil 3511/2025 arising out of WPC number 3102/2025. In the order dated 23/3/2026, there was a direction upon the petitioner in WPC number 3102/2025 to make payment of the dues to the applicant in terms with section 17 capital B of the Industrial Disputes Act 1947. Mr. M. Sharma, who appears on behalf of the respondent, submits that the amount of rupees, give the amount, have already been paid to the petitioner. So taking into account the above, nothing further remains in the instant contempt application, for which the instant application stands closed. Now, in the main matter, what has happened? Records have come. Okay, we do one thing. We call for the records. What is the order for? You have challenged an award. Where is the award? Hmm? Okay. Heard Mr. Heard Mr. Mr. M. Sharma, the learned counsel appearing on behalf of the petitioner, and Mr. FZ Muzumdar, who appears on behalf of the respondent number. Sole respondent. The present application has been filed challenging. The present petition has been filed challenging the award dated 16/12/2024 passed by the learned presiding officer, Industrial Tribunal, Gauhati, in reference case number 4/2022, whereby the learned Industrial Tribunal have passed directions for reinstatement of the petitioner with full back wages. First, it is the opinion of this court that the matter requires an urgent disposal, taking into account taking into account the present proceedings is a case of an industrial dispute. First, it is also the opinion of this court that the records of reference case number 4/2022 would be required for an effective adjudication of the present proceedings. Accordingly, this court calls for the records of reference case number 4/2022 from the court of the court of the learned industrial tribunal, Gauhati, Assam. The registry shall take effective steps to ensure that the said records are available before this court on the next date so fixed hereinafter. List this matter for final disposal on 27th of August 2026. Mr. Hawk, what is this against water resource? Yesterday you said that it is going to be given to a L2, but you are asking this court that you have not mentioned anything that of any prayer to that effect. Yes, madam. So therefore, one thing one can assert that there is no move to give it to any third party, I suppose. So then we do one thing. We pass a limited interim order that you can give it to him if he is the L1 bidder, but not to give it to anybody else till the next date. Get your instructions to that effect. It will be a limited interim order. I'll fix it on 1st of June. Issue notice making it returnable on 1st of June 2026. Ms. So-and-so accepts notice on behalf of the respondent numbers 1, 2, and 3. Extra copies of the writ petition be served upon her during the course of the day. Pursuant to a notice inviting tender dated 26/8/2025, for various works issued by the Chief Engineer of the Water Resource Department, which included the work of construction of embankment on R/B of river Buradia from Krishnaguru Sewa Ashram to Purni and Purni to Triveni Ghat, including 2 shutter sluice at Purni under Nalbari Water Resource Division, amounting to rupees 800 lakhs. Of the estimated contract value of rupees 800 lakhs, the petitioner participated in respect to the said work. It is the case of the petitioner that the petitioner was technically, the bid was technically responsive and was the lowest bidder. First, this, when it was found out that you were the lowest bidder? No, this is technically. Where is the lowest bidder? The said aspect is apparent from Annexure E, more particularly page 89 and page 89A. It is the further case of the petitioner that though the financial and technical and financial evaluation was carried out as far back as on 2nd of 23/2/2026, isn't it? But till date, the tender have not been, the settlement and the contract in question have not been awarded to the petitioner. The petitioner further apprehends that there is a move to give it to grant the tender to the second lowest bidder, and it is under such circumstances the petitioner has approached this court. From the materials on record, this court finds it very pertinent to observe that materials on record, and more particularly Annexure E, it is seen that the petitioner appears to be the technical responsive, as well as the petitioner's bid is the lowest bid. First, under such circumstances, it is the opinion of this court that the petitioner has been able to make out a prima facie case for grant of prima facie case for certain interim directions. Accordingly, till the next date, the respondent authorities are directed not to allot the tender, the work in question, to any other bidder. For any other bidder. First, it is clarified that the said interim order shall not preclude the respondents to grant the contract to the petitioner if otherwise satisfied with the petitioner's credentials. How much? The petitioner, the Mr. So-and-so, who appears on behalf of the respondent number 1 and 3, submits that in respect to the balance amount payable to the petitioner, the same could be placed in the budget session so that necessary sanction can be granted from the finance department. So taking into account the above, list this matter again on 17th of July 2026 for an update as to whether the amount, the remaining balance amount have been paid to the petitioner or not. Service complete. Service being complete leaves the matter for, what is the matter about? How much? Huh? 65 lakhs remaining. Okay, you do one thing. Verify and pay. 6 months. Okay. Nabar is, therefore, service is complete. So if they don't appear, what to do? Newly implemented. Huh? You do one thing. This service is completed. How? This court have duly taken note of the order dated 18/5/2026 of the Lozima Court, wherein it is mentioned that the service of notice upon the respondent number 6 have been completed. The said observation made in the order dated 18/5/2026 by the Lozima Court is based upon the speed post track consignment details. First, taking into account that the NABARD's presence, taking into account that the NABARD's presence would be essential in as much as the fund has to be also released from NABARD to the Assam State Agricultural Marketing Board, isn't it? For due payment to the petitioner, it is the opinion of this court that the petitioner should effect service upon the respondent number 6 by way of dusty. Accordingly, this court, accordingly, the petition is fixed again on 27th of July 2026. In the meantime, the petitioner is directed to take steps upon the respondent number 6 by way of dusty, routed through the registry of this court, and file an affidavit of service on or before the next date. First of this, petitioner should ensure that the service by dusty upon the respondent number 6 is meted out on or before 10th of June 2026. This order cannot be complied with. Who? Understood. But this order can't be complied with. On one hand, you say Tamsir Ali. Tamsir Ali says what? Once you fill up the post, or find out how much he is entitled to, you put him in the chronological table. Chronological table, it will be paid as per when his right accrues. And right accrues means it will be paid serial one. This is Tamsir Ali. If you apply Tamsir Ali, you can't have it within 3 months. Impossible. Order seems to be wrong. So now you want to implead. Mr. N.R. Sharma, who appears on behalf of the respondent number 1, submits. The learned counsel who appears on behalf of the respondent number 1 submits that the respondent number 1 is no longer holding the post of the principal secretary of the BTC. He submits that Mr. Mukesh Sahu is the present incumbent to the post of the principal secretary BTC. Mr. So-and-so, appearing on behalf of the petitioner, submits that he would like to file an appropriate application for impleading the present incumbent. For taking into account the above, list this matter upon such application is filed. You got the money? They've not paid you. Why? And nobody is appearing also. So we have the presence of the commissioner. Here. Ah. When are you paying? What is that? Mr. Esbora, the learned counsel who appears on behalf of the contemptor in the present batch of contempt applications, submits that the contemptor have sought for funds from the Housing and Urban Affairs Department of the Government of Assam, and immediately upon payment being made, the amount would be released to the petitioner. In that regard, he had referred to the communication of August 2025. Full. It is the opinion of this court that the said communication was in the month of August 2025, and there appears to be no such action taken in recent past seeking for funds to meet the liabilities which is payable to the petitioners herein. Mr. Espora submits that the contemner shall do the needful so that the funds can get allocated. The funds required can be taken into consideration in the coming budget session. Taking into account the above, list this matter on 29, list these matters on 29th of July 2026 for an update. You want to strike out in both the writ petitions. Okay. Mr. So-and-so, who appears on behalf of the petitioner, submits that the respondent number 8 in the present proceedings is not a necessary or a proper party. He therefore submits that the name of the respondent number 8 may be struck off. The respondent number 8 may be struck off from the array of parties in the present proceedings. Mr. R. Gogoi, appearing on behalf of the Forest Department, as well as Mr. S.R. Borwa, appearing on behalf of the District Commissioner, has no objection, taking into account the respondent number 8 is struck off. The name of the respondent number 8 is struck off from the array of the parties at the risk of the petitioner. First, in that view of the matter, the service is complete. Leaves these matters for admission in the third week of June 2026. At least this matter, the second one is disposed of, na? Yeah. Okay. List these matters. Which one? Item? What is that? Hmm. You're working? Are you working? Gainfully employed? Why you're not filing that application on the 17B? File that application on the 17B, you will get the last year and the what do you call the last wages. Huh? You have attained the age of superannuation. Chalo, then we have to do it fast. You file your affidavit. We don't require an affidavit. Why do you need an affidavit? We only require the records. Dispose it off. Now itself. Ready? Argue? What is wrong with the order? So here the question of reinstatement would not arise. It is only the case of back wages, isn't it? Why you are not paying the back wages? How much it would be? Huh? How much? Find it out. How much? Back wages. There is no question of reinstatement. Pay him and finish it off. What is there? What did he do? Why did you terminate him? Why was he terminated? How much? Ah, Ah. Hmm. Then, however, the workman declined to examine any independent document cause financial loss to the payment also. How can there be a misappropriation without the money having gone to others? Come up with a figure. It's only the question of reinstatement does not arise. Back wages. Pay him. That, how many years? 2007. Pay him some money and finish it off. Both of you. Go to the, what do you call that? Don't go to mediation. Both of you discuss. And after discussing, come up with a figure. Tell me. We fix it. Close it. Matter over. Because otherwise you have to pay back wages. What is wrong? Right. And this court's interference power is very less. Because your management witness number one says, let's see his evidence. These matters doesn't take too much of time. We charge. Wait. Inquiry held on so and so. Word acquisition. Santipur. Don't break it. Got it. Right? MW1. So MW categorically says it is not a fact that Keshav Bora had not misappropriated rupees 88,550. Payments are made by two office staff. Keshav Bora entered the names of 20/22 women workers falsely on the payroll with the intention to misappropriate the same. The amount of rupees remained with the management as could not be disbursed. Well, it is not a fact that Keshav is not involved in entering the names of Ia. It is also not a fact that Ia. Now, did you produce that document that he has entered into? Now, let us see the Ia of Mintu Das. What does it say? Mintu Das. I worked Ia. It is not a fact that I stated before Ia Keshav assaulted me. It is not a fact that I wrote to the manager. So you have two allegations. One is 88,000 misappropriation gone, and Mintu Das, upon whom he assaulted, he also gave evidence that I was never assaulted. What remains? Huh? Now that is his cross-examination. Kindly see Mintu Das cross-examination. I worked in Bedjanti state. Workman Keshav did not assault me. It is not a fact that I stated before the inquiry officer that Keshav Bora assaulted me. It is not a fact that I wrote to the management that Keshav Bora assaulted me. I stated BCom but did not. At the time of inquiry, Keshav Bora was also present there. It is not a fact that during inquiry I stated before that Keshav Bora assaulted me and my signature was obtained. It is not a It is also not a fact that I have submitted one letter to management that Keshav Bora assaulted me. All are denied. No case. Pay him. Should we dismiss it? What? Next week. Next week. 2 minutes. We dismiss with cost. This type of matters cannot go. And they just stay. Who say? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so who appears on behalf of the respondent. Number one. Full stop. Taking into account that the taking into account the settled principles of law that the presiding officer of the industrial tribunal have passed an award in exercise of his judicial functions. This court strikes out the name of the respondent number 2. Therefore, the service is duly complete. It is also seen that the records further reveal that the award dated 21/2025 passed by the Learned Industrial Tribunal, Dibrugarh, in reference case number 4/2012, have been stayed. Learned counsel who appears on behalf of the respondent number 1 submits that in the meantime, the respondent number 1 have crossed the age of superannuation. Under such circumstances, the directions in the award dated 21/2025 in reference case number 4/2012 have only to be limited to whether the petitioner herein would be entitled, respondent number 1 herein would be entitled to the back wages. This court have also perused the materials on record as well as also the records of the Learned Industrial Tribunal in reference case number 4/2012. The learned counsel appearing on behalf of the petitioner submits that he is not ready to do the hearing. Considering the above, and in the spirit of an early resolution to the industrial dispute which have been going on for the last 19 years, this court fixes the instant writ petition for final disposal on 11th of June 2026 at the top of the list. What? What is there to interim order? Nothing is going to happen. The records are here. He cannot file an application under 29. What do you mean? List the matter for further hearing. Mr. Counsel, I am going to finish it off. In the meantime, both of you agree to an amount. Else, you have to pay back wages from 2007. Here's a good case. Yes, what is this? Item 20. Why the matter has come up? Affidavit in opposition has been filed by so and so. Imyat till date, no wakalatnama filed by respondent number 9. Who is respondent number? Whose? 9. Whose revoked? Respondent number 9 is who? State Environment Assessment Authority. Why he is appearing? Okay. So Mr. S. Bulwa would be appearing on behalf of the respondent number 9. Respondent number 9 and 10. Under such circumstances, the service is duly complete. Yes, now what do you have to say? I'm not on that. So the service is complete. Under such circumstances, the service being complete, list is for admission on 27th of May 2026. What is the matter about? Market? What remains? Market is ending on 36. Oh, withdraw. Ah, okay. So we do one thing. Service is complete. Service is complete. List the matter for admission on 27th of May 2026. Interim order passed earlier shall continue till the next date. Let him do the matter on 27. He has a good case. Mr. FZ Muzumdar, where is he? Huh? What? Okay, you will have it on 29th? On, she was saying on 10/6. 10/6. Okay, list the matter on 10/6. What is this? Hello. None appears on behalf of the petitioner. Record size है? Full stop. You are appearing for the respondent, na? Okay. Taking into account that the service is complete, list this matter for final disposal on 13th of August 2026. For admission, list the matter for admission and for final disposal on that. Order passed. Mr. B. Gogoi, the learned standing counsel of the NHEM, submits that the order passed by the court dated 17/3/2025 in WPC number 1448/2025 have been complied with inasmuch as by a speaking order dated 21/5/2026, the representation of the petitioner have been duly disposed of. The copy of the order dated so and so, dated speaking order dated 21/5/2026, is kept on record and marked with the letter X. A copy of this order have also been furnished to Ms. K. Devi, the learned counsel appearing on behalf of the petitioner. Taking into account the above, the instant contempt proceeding stands dropped. However, it is observed that the dropping of the instant contempt proceeding shall not prejudice the petitioner to challenge the speaking order as dated 21/5/2026, as well as seek consequential reliefs if so otherwise entitled under law, permissible in the law. Right. Where? Where is the order? Has it been numbered? Huh? What is the number? 20? 26. Mr. D.K. Sharma, the learned counsel who appears on behalf of both the contemners, submits that a writ appeal has been prepared against the judgment and order dated 14/7/2025 in WPC number 7324/2013. The filing number, he submitted that the said writ appeal, however, have not yet been registered, but the filing number of the said writ appeal is so and so. The learned counsel, Mr. D.K. Sharma, the learned counsel therefore submits that some time may be granted for obtaining stay to the directions passed by the learned court bench of this court, stay to the order dated 14/7/2025 in WPC number 7324/2023. Taking into account the above list this matter on 24th of June 2026. For an update. Order 6. The respondents herein, and more particularly the respondent number 1 and 2, are jointly and severely directed to regularize the services of the petitioner with effect from 27/7/2007. That is the date on which the proposal was submitted by the Director of Fishery for normalization of the FFDA post to the state plan post. The said exercise be carried out by creating supernumerary posts against each of the petitioners within a period of 3 months from the date of the present judgment. It is observed and directed that while regularizing the services of the petitioner as directed above, they should be provided with protection of their pay and allowances. As it is the specific case of the petitioners that the petitioners are getting the scale of pay as is given to regular government employees of equal status, there shall not be any requirement of payment of any amount towards arrears upon regularization. However, it is observed and directed that upon regularization with effect from 27/7/2007, the services of the petitioners would be counted for all other service benefits, which pension, leave encashment, gratuity, and other terminal benefits which is enjoyed by the regular government employee of equal status. This court duly notes that some of the petitioners have in the meantime retired. They would also be entitled to all benefits as have been directed in the preceding clauses. In addition to the above, these retired petitioners would be entitled to leave, pension, leave encashment, gratuity, and other terminal benefits. The arrears of the same be paid within 6 months of the present judgment. You see, for regularization, 3 months, because those who have retired, then there will be arrears. Otherwise, those who are in service, there's no arrears. This court further directs that in the circumstance, if any of the petitioners have expired, their family members would be entitled to all such benefits which the family members of a regular government employee servant enjoys of equal status appointed as on 27/7/2007. The Commissioner and Secretary of both the Fishery Department as well as the Finance Department shall file compliance affidavits to the aforesaid directions within 8 months from the date of the present judgment. No cost. Before parting with the record, this court finds it relevant to observe, for the sake of clarity, that as this court has held that the rejection of the proposal by the Finance Department to normalize the FFDA to the state plan to be arbitrary, unreasonable, and suffering from malice in law, the directions here issued herein above shall not preclude the state of Assam to convert the FFDA post to the state plan oblique non-plan post if felt necessary for administrative reasons. I've also mentioned one thing. The reasons above assigned would therefore show that the rejection of the proposal to normalize the post in the FFDA to state plan post by the Finance Department is arbitrary, unreasonable, and suffers from malice in law. However, it is equally important to know that how the state would administer its departments are absolutely within the domain of the state government. Interference in such respect by this court in exercise of the powers of judicial review would be transgressing into the powers reserved upon the state by the Constitution. Under such circumstances, it is the opinion of this court that this court cannot issue a mandamus directing the state to normalize the post in the FFDA and bring them within the fold of the state plan. But here I understood what is normalization. Anyways, I've written something, huh? I therefore say, I didn't say much. I made it very clear. No? It will be from 27/7/2007. You know it. It's 53 for judgment. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The impugned order dated 15/12/2023 passed by the Commissioner, Department of Industries and Commerce, Government of Assam, being unreasonable and arbitrary, is in violation of Article 14 of the Constitution. Accordingly, the impugned speaking order dated so-and-so is set aside and quashed. A perusal of the records clearly showed that the petitioner had duly submitted all the documents as required in clause 9 of the relevant guidelines prior to forwarding of the petitioner's application by the General Manager, Industries and Commerce Department, Silchar, to the State Mission Director. The petitioner, being encouraged by the NMFP scheme, have taken a term loan and also invested capital, thereby changing its course, and therefore the respondents herein are stopped by the principles of promissory estoppel from denying the petitioner the benefits under the NMFP scheme of grant in aid, subject to further consideration of the verification as regards the quantum. The claim of the petitioner comes within the ambit of committed liabilities as mentioned in the communication dated 27/3/2015 issued by the Secretary, Ministry of Food Processing, Government of India, to the Chief Secretary, Government of Assam. Accordingly, this court directs the respondent number 2 and 3 to take immediate steps for setting up a committee in consultation with the respondent number 1 to evaluate the application submitted by the petitioner on 26/3/2014, which was forwarded to the respondent number 5 on so-and-so, and thereupon take a decision as regards the petitioner's entitlement for sanction of the grant in aid in terms with the NMFP guidelines and the relevant guidelines. This court further observes and directs that while making such evaluation by the committee to be constituted by the respondents herein as directed above, the committee shall duly take into consideration the observations made herein above, that it is only for the release of the first installment or the second installment the documents mentioned in clause 8.1 and 8.2 would be essential and not for the purpose of considering as to whether the petitioner is entitled to the grant in aid. For the sake of clarity, this court observes that the present adjudication is in relation to the rejection of the petitioner's proposal. The legality and validity of the impugned order dated 15/12/2023, as well as whether the petitioner is entitled to claim benefits under the NMFP guidelines and the relevant guideline. This court has not decided as to what quantum of granting aid the petitioner would be entitled to. The same shall depend on the decision of the committee so directed to be constituted herein above. The above exercise be completed within a period of 6 months from today. The records which have been produced before this court is returned back to Mr. B. Gogoi, the learned additional AG Assam. Very good. I therefore said it to be committed liability. Once it is a committed liability, what you see, in fact, the arguments at that point of time was we were going into other aspects. This question is on 27/3/2015, there was a direction that, look here, we are delinking from ourselves from 1/4/2015, and thereupon you make the payments from your own resources. And these resources would come, and therefore there was a direction that you make payment of all the amounts which is in respect to projects wherein it has been approved by the SLEC as well as committed liabilities. So the moment I say it to be committed, then you know what is to be done. Return the records, huh? In fact, Mr. Gogoi, you should have made that submission. It falls within the committed liabilities. Once it falls within the committed liabilities, everything is out. And in fact, all the officers of the Industries Department have been asking that whether it is a committed liability or not, and the ministry has not answered that. That is why the problem arose. The impugned communication dated 21/2023 issued by the Secretary to the Government of Assam Judicial Department to the Government of Assam Judicial Department to the presiding officers of the Labour Court Industrial Tribunals of the State of Assam is set aside and quashed. The non-judicial officers and staff of the Labour Courts Industrial Tribunals in the State of Assam, which includes the post of the Register, Industrial Tribunal or Labour Courts, would come within the ambit of officers and staff of the subordinate courts, and therefore under the control of the Gauhati High Court in terms with Article 235 of the Constitution. The post of the Register, Labour Courts Industrial Tribunal would come under the control vested upon the Gauhati High Court under Article 235 of the Constitution, irrespective of the fact that a person is appointed by the Judicial Department or the Labour Department. It is the Gauhati High Court on the administrative side who would have the competence to decide the parities of status and employment amongst the members of the judicial service as well as the non-judicial officers and staff working in the subordinate courts within the jurisdiction of the Gauhati High Court. Neither the Finance Department of the State of Assam nor the Assam Pay Commission would have the competence on that aspect, inasmuch as it would impact on the independence of the judiciary, which is a basic feature of the Constitution. Under such circumstances, the State of Assam could not have taken a contrary view to the opinion of the parity in employment and status as opined by the committee constituted by the Honorable Chief Justice, that is the Committee for Consideration of the SETI Commission's recommendation on revision of pay scale, etc., of the subordinate court staff of Assam in the minutes of the meeting dated so and so, and more particularly to the resolution number 5. The services rendered by the Register of the Industrial Tribunal or Labour Courts are similar to that of the Seristadar, Chief Administrative Officer of the Establishment of the District Judges, MSCT, special judges, CBI, NIA, NDPS, as well as the judge designated court. And as such, the post of the registered industrial tribunal oblique labor court should carry the same scale of pay along with grade pay to that of the chief administrative officer of the court of the district judge, MSCT, special judge, CBI, NIA, NDPS, as well as so and so. The status of the Industrial Tribunal oblique Labor Court is at par with the MSCT, and under such circumstances, granting a lower scale of pay and grade pay to the Registered Industrial Tribunal to that what is enjoyed by the post of the Chief Administrative Officer MSCT violates the fundamental rights of the person holding the post of the Registered Industrial Tribunal oblique Labor Court in the state of Assam under Article 14 and 16 of the Constitution. The state of Assam, more particularly the Finance Department of the Government of Assam, the Judicial Department of the Government of Assam, as well as the Gauhati High Court are directed to take steps forthwith to pay the equivalent scale of pay along with the grade pay to the petitioner, as well as other officers holding the post of the Registered Industrial Tribunal, oblique the labor courts of the state of Assam, equivalent to the scale of pay and grade pay of the Chief Administrative Officer, MSCT, with effect from the date the Chief Administrative Officer, MSCT, has been provided with the equivalent pay scale and grade pay to that of the Seristadar of the establishment of the district judges. The area to which the petitioner would be entitled to shall be paid to the petitioner within 6 months from the date of the present judgment. The Registrar General, Gauhati High Court, the Commissioner and Secretary of the Finance Department, as well as the Commissioner and Secretary to the Judicial Department of the Government of Assam are directed to file compliance affidavit to the aforesaid directives within 8 months from the date of the present judgment. There shall be no order as to cost. Before parting with the record, this court finds it relevant to make an observation on the stand taken by the Gauhati High Court in the affidavit in opposition filed on 28/10/2025 in the present proceeding. It is pertinent to note that the Honorable Chief Justice of the Gauhati High Court had constituted the committee for consideration of the SETI Commission's recommendation on revision of pay scale, etc., of the subordinate staff of Assam. The opinion and the resolution adopted by the said committee had the concurrence of the Honorable Chief Justice. The committee acted on the authority granted by the Gauhati High Court under Article 235 of the Constitution, insofar as the implementation of the recommendations of the SETI Commission. It is disheartening to note that the Gauhati High Court in the present proceeding have taken a contrary stand to the resolution number 5, dated 5/10/2012 of the Committee for Consideration of so and so. That too, without placing anything on record that the said resolution number 5 at any point of time at any point of time at any subsequently stood amended, modified, annulled by the Gauhati High Court on the administrative side. There was one judgment on RegNet, you see that. That was a case pertaining to as to whether district judges and presiding officers of industrial tribunals would be getting the same scale of pay. In Kerala, that scale of pay was not granted on the ground of the manner of recruitment. Supreme Court said, no, you have to give them because they forget about all other things. They come within the ambit of the subordinate courts. Secondly, if you see the recent judgment on the second pay, National Judicial Pay Commission, there's one paragraph I've quoted out there in the All India Judges Association. There it says that in labor courts, there are persons who may not be from the judicial service, but they are then also come within the subordinate courts, and as such, those persons who are not judicial officers also will get the same scale of pay. Not only 235, the basic feature is the independence of the judiciary. where everything comes in. Because once they fall within it, then you cannot have anything else. What is this? So, in view of this affidavit, we wait for some time, thereby giving the authority who appears for response number 5. Huh? You are response number 4. So it is within prescribed limits. Okay, you do one thing. You are who? Huh? You are response number 4. Director compliance, na? You ask somebody from your office to place it before in the hearing before the response number 5 who is taking it up so that he can proceed with it. 20? On 25th, the hearing is fixed. So you place this there, better off. Huh? This one, give it to her. You have a photocopy? Give it to her. Instead of giving it to Mr. J. Roy, who is the beneficiary of the actions. Pursuant to the order passed by this court on 26/2026, a detailed affidavit has been filed by the respondent number 5, clarifying the stand as to under what circumstances, as to what further steps have been taken First, it is seen that the present district commissioner have joined his office on 5/1/2026. Further to that, in pursuance to the order, further to that, it is also taken note of that the order dated 26/2026 having been placed before him, hearing is being taken up amongst the stakeholders. Is to be taken up amongst the stakeholders on 25/5/2026. It is the opinion of this court that that this court should await the result of and await for further orders, should await for the speaking order which the respondent number 5 would be passing pursuant to hearing the stakeholders as have been mentioned. And then, full stop. Accordingly, list this matter again on 22nd of July 2026. This court also have taken note of the submission of Ms. K. Phukon, the learned counsel appearing on behalf of the respondent number 4, who have placed before this court the result of the EMR testing, wherein it was found that what is this item? The mobile tower in question, that the radiation level in respect to the mobile tower in question is within the prescribed limits. This court is of the opinion that the said results also be placed before the respondent number 5 in his hearing, which would aid him in arriving at a just decision for passing the speaking order. First, list according. I will put everybody. You have no submissions. Do you have any submissions? So, Mr. J. Roy, the learned senior counsel, submits that he appears for 13 and 14. Would it look nice for a senior advocate making that submission? Then, we continue. Your name would be put out there. They will put golden letters or 30. What? Termination answer. Mr. So-and-so, who appears on behalf of the petitioner, submits that the affidavit in opposition filed by the PWD department, PWD, have been received by him today, and he would like to go through the same, and if necessary, file a reply. Urgency, no urgency. Bill payment or what is that? Termination, no urgency. Okay. List this matter again on 12th of August 2026. In the meantime, reply be filed if necessary. It'll आएगी वो. Huh? What is this matter about? You don't have urgency. You don't have urgency. Otherwise, you would have said that, my lord, may kindly take up this copy of my reply, or you would have called for that reply. You have not. You don't have urgency. What is the order of 9795/2024? Well, where is that order? Allotment of land for shop for Iman. As per the application, you are hereby allotment of land for shop at so and so Daily Bazaar area measuring 24 feet and Iman in north so and so for a period from so and so on purely temporary basis. Now, what you are said? Why do you want the withdrawal of this order? This was given to Babu Sharma. Who is Babu Sharma? You are Babu Sharma. And this letter of 19/4/2024 has been issued to you. Then, where is it state? This order will cancel at any time without any notice and assignment. Where is the stay? Where is the stay of the order? Four. Huh? It is with respect to the Iman, a government allotment of so and so. The boundary of the backside is the wall of government hospital. We uttered that the letter on the above mentioned so and so died to stay temporary the construction of the allotment in the shop. Where is that order? Which stayed? Where? This is a letter written by you, page 24. You are not ready. The counsel appearing on behalf of the petitioner submits that he has filed a reply yesterday, and accordingly, this court may call for the records of the said reply. To list this matter again on after vacation. After vacation, nothing will remain. List this matter again on 5th of June 2026. In the meantime, the reply of the affidavit affidavit on reply so filed by the petitioner be brought on record by the registrar. What interim order? Status quo is there, it will continue. Interim order, if any, stands extended to the next day. Silogudi. What is this, Mr. R. Singh? What is this matter? Huh? So what are you asking, Mr. Counsel? 68 lakhs. You have not completed the work. So are you entitled to 48 lakhs? Huh? Hmm? When was the work order allotted to him? A letter of acceptance was issued on 2012-7. Where is your completion certificate of 70%? Show me. Not empowered committee, in your petition, where is it? That you have been granted a letter of acceptance is what? Huh? Oh, no. Document. What is page 141? Annexure 4. We are concerned with which work? Reconstruction. Papita to so and so, road under so and so, 68 lakhs 78,000. Now, this was the work. Now, what is the share has discussed the area? Where? Why do you say that you have done the work? Where is your completion certificate? Huh? Page. Page. Annexure 10. No, tell me, my concern is this work, period of work is how much? Where is your letter of acceptance? Where is your letter of acceptance? Huh? This very work has been subsequently granted to another at 68 lakhs 63,000. No, Mr. Counsel, let us see your which work you are asking for. Executive engineer, I don't trust. PWD, very difficult. I don't trust them. No. Mr. Counsel, if you are out here on the basis of Mr. the PWD, I don't trust PWD. Very difficult. PWD is not to be trusted. And that to executive engineer. Two department executive engineer, I don't trust is PWD and water resource and PNRD. Better civil court. No, this is a very serious allegation which has happened. This work was allotted to you of rupees 68 lakhs 78,000. Okay. Now they say that this very work you withdrew and therefore that work was given to one Rizwan Ahmed Chaudhary. And in pursuance to that, Rizwan Ahmed Chaudhary has also been paid the amount. So therefore, it is a very serious disputed questions of facts. We can't entertain. Don't rely on PWD. Huh? No. Mr. Gogoi, do you know what has happened actually? No, that is not that. He says, kindly come to 141. See the work at number 5. This was the work allotted to him. Here he says that kindly see this document at kindly come to page 201. This is written by the chief engineer PWD, border roads. Okay. Then the next page is shows some 8 lakhs 46,000 is the total amount. So whatever tax invoice. Okay. Then you see the executive engineer PWD in respect to the said work 204. This is a different work. Bhagatgaon. Mr. Counsel, this is Bhagatgaon. It is Bhagatgaon. But you are claiming out here for the Popetia. Popetia to Kotkotia, Bhagatgaon. It's the same. So here the executive engineer says 48 lakhs is to be released. 4 lakhs, na? 4 lakhs is to be released. Then he says these are all the certificates which have been given. So therefore now he is claiming that give me 48 lakhs out of 68 lakhs. That is he said. On the other hand, kindly come to page 224. In this case, you see this very work The letter of acceptance is dated 12/7/2022. And he has given up on 8/8/2022, saying that I don't want to do at this time. Pursuant thereto, the work was issued to one Rizwan Ahmed Chaudhary. Rizwan Ahmed Chaudhary completed, and therefore you see the completion certificate at page 226. Rizwan Ahmed Chaudhary has been made the payment, as you see from the financial sanction. So nothing remains. So he now is claiming in respect to the same work 70% on the basis of some empowerment. That is why I asked him, where is your letter of acceptance? Mr. Counsel, where is your letter of acceptance? Letter of acceptance for the work you are asking. Where is the letter of acceptance? Where is your work order? Your basic case is no case. That is the most important document. Now, or the learned counsel appearing on behalf of the petitioner. Mr. S. Datta, the learned counsel who appears on behalf of the Mr. B. Gogoi appears on behalf of the PWD Border Roads. And Mr. S. Datta, who appears on behalf of the Revenue and Disaster Management Department. The petitioner herein claims an amount of rupees. I think we dismiss with cost. Cost. No, your additional affidavit, you go and file wherever it is. I'm dismissing it with cost. This type of cases cannot be answered. And you are asking the petitioner herein is claiming an amount of rupees 48,14,600. That is 70% of the total PR bracket SDF sanction amount of rupees 68,78,000. In respect to a work carried out by the petitioner, pertaining to reconstruction of the repairs of Patiapa to Kotkotia, Patiapa to Kotkotia, Katia, Bhatgaon Road, providing by artwork, GSB, WBM, GR Roman 3, protection work and CD works under PR, bracket PR, SDRF for the year 2020-21 of 2.69 kilometers. The records, this court have duly taken note of an affidavit which has been filed by the respondent number 6. On 19th of May 2026, wherein it is categorically mentioned that though a letter of acceptance was issued on 12/7/2022, but the petitioner gave up the said work and declined to accept the letter of acceptance and informed the superintending engineer PWRD by the communication dated 8/8/2022. Subsequent thereto, This is another work. No, 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 Mr. Counsel. This is a construction and maintenance of rural roads under Pradhan Mantri Graham Sarak Yojana 2018-19. This is 2021. These minutes of the meeting is 2021. So you are asking for which work? Here, no, 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 Mr. Counsel. Here, Mr. Counsel, this is the work order of 2019. Submitted. On the other hand, the respondent was submitted that the said work, the petitioner has refused and declined the said letter of acceptance dated 12/7/2022. Pursuant thereto, a notice to proceed with the work was issued to one Rizwan Ahmed Chaudhry on 31/8/2022 for the work, for the contract, for the said work of an amount of rupees 68,63,994. It is also mentioned in the said affidavit filed by the respondent number 6 that the completion that the said Rizwan Ahmed Chaudhry had duly completed the work and have been made, and payment have also been made of an amount of rupees 68,62,524. The materials on record therefore show that there are serious disputes in the instant proceedings as to whether the petitioner carried out the work by himself and is entitled to the amount as claimed in the instant writ petition, or the work was allotted to somebody else who completed the said work and thereupon received the payment. These disputed questions of facts cannot be decided in the present proceedings, inasmuch as the same would require evidence to be led and the assertions made in the instant proceedings to be proved. First, as these disputed facts, further to that, these disputed facts, further to that, adjudication of these disputed facts would be cumbersome. Now, on the basis of affidavits cannot be decided, for which this court is not inclined to entertain the instant petition. Accordingly, the petition stands dismissed. Liberty, however, is given to the petitioner to approach the civil court of competent jurisdiction if so advised, seeking recovery of the amount in respect to the work done and completed by the petitioner. This court also takes note of that the petitioner have been diligently pursuing the instant proceedings, and accordingly the period from 30/10/2024 till date be excluded while computing the period of limitation. Very. You prove that. What? Who are you? Who is response number 5? Your mother-in-law, you want a wine shop. What is wrong with your people? 71-year-old woman, she wants a wine shop. Huh? Why? We say, therefore, you give it to Dia that her business cannot be stopped on account of these family disputes. Yes. How is a mother-in-law? Mother-in-law is not asking that she is going to run. Forget about the NOC. I'm not on the NOC. I'm not on the question of NOC. Why are you insisting on the NOC? They are not going to claim the license. They are only not giving the. Are you going to run it? Get your instruction. I don't think you are going to run it. How will the 71-year-old lady run it? Wine shop? Hmm. So you mean to say that you want to destroy the entire business out of a fight between both of you and not like to settle it? Is it something like that? It appears to be. So you say that, okay, let her not get it, let me also not get it, she also should not get it, nobody should get it. Because of the fact that I had invested some money, I forgo that amount also. You make a claim as regards whatever amount is due from you from the or any investment that is separate. But if you don't allow this thing to run, how will you get the money? Huh? So because of the bitterness, you go to the civil court and fight out. Not here. But oh, fantastic. That will be looked into. Now don't insist on their NOC. Go ahead and give it to them. Let her run if she has renewed it. Have you renewed it? Closed. Okay, you pay. They will renew it without insisting on that. And whether they will be entitled to or not shall be subject to the partition suit. But you cannot impose. You can very well, in the partition suit, you can very well ask for profits. Don't you think so? These profits, this license was actually belonged to her husband. So he was running. So if she is running certain amounts, if you are entitled on the basis of being a class 1A, you'll also be entitled to the profits. So that will go. So we do one thing. You have submitted a representation. Okay. Let them consider. You consider without insisting on the no objection, subject to payment. We will see on the next day what happens. No, here it is not renewed, not because of her fault. The renew is because of the no objection given, but not given, which you are insisting. Understood? Does the rule say that the no objection from others? So then, why you are insisting on a condition? So the fault is not of hers, the fault is yours. You are not renewing because of asking for a no objection. So she is claiming. Don't worry with that. I'm passing that order now. He will say out there that they will fight it out as regards the profits in the civil partition suit. Bring it, amend it. Or we will make an observation, because you will be not only asking for others, no matter what, this will not take us. Okay, let her, your representation you consider without this, and it also appears that I'm good. Okay, heard Mr. So and so, the learned counsel appearing on behalf of the petitioner, Mr. R.R. Gogoi. If it was a male person, then I would have taken it differently. But you have to see why she's a widow now. Huh? Oh, this is something to do with that building. Yes, building. No, no, no. These type of people would not get. Oh, you file your affidavit. No, 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 no. You are. I was thinking of these people. There are a lot of other. You people are all well to do. Not, you are not a bad. No, you are well to do. Sorry. You file your affidavit. Sorry, sorry. These type of people are not going to. You want to file a reply. Okay. Miss So and so submits that she will file a reply. At least this matter. When is the matter again? On 17th of June 2026. In the meantime, the reply. Matter pertains to got an interim order. So you have asked for recovery. Where's the interim order? 16.5. You are not in an urgency. No affidavit has been filed by the respondents till date, in spite of. there being an there being an interim order dated 16/5/2025, operational till date. Considering the Mr. S.S. Roy submits that the affidavit would be filed within submits the affidavit have been upon being filed, are certain defects. Considering the above, list this matter on 23rd of September 2026. In the meantime, the respondents shall rectify the defects, and the petitioner, upon receipt of, have you received a copy of the affidavit? Upon receipt of the copy of the affidavit, is granted the liberty to file reply. Interim order passed earlier shall continue till the next day. If he doesn't hear the defects, no, it's very difficult to trust. Trust issues. Okay, we have it on 3rd of August. Yes, Mr. Doctor, what is this case? Oh, that one. I've asked you to submit a representation or something like that. So they have given it perspective. They have given it perspective. Perspective. No, they have, I'm more correct than you. They have withdrawn the blacklisting prospectively. So therefore, that period prior to that, that is why the matter is here. I know that. What is it? What is there now to do? Why? It's a case of blacklisting. So we put it out there that your writ petition will be only limited to the question of blacklisting, nothing else. Then your maintainability issue is taken care of, isn't it? I passed it. So then the question of maintainability does not arise. Because blacklisting, if it is in violation of Article 14, Article 14 of fundamental rights, if it violates your fundamental rights of the 14 and 21, obviously, then there is no stopping the court from exercising the jurisdiction. So that is the only objection. Anything more? But you don't want to say because Mr. Ndeka is not there today. Huh? Did you issue notice before blacklisting? Hmm? No. That is the fundamental issue. Mr. S. Doctor has been stating that right from the beginning, from the day on which this court issued notice, this is the only issue. Isn't it? Then You have by way of an additional affidavit challenged the impugn order, no? So to be, I granted you the leave. Okay. Hello. You're not prepared. It seems so. The counsel for the Numuligo Refinery Limited, isn't it? Is not prepared when the matter is being called for. Considering the above, list this matter again on 12th of June 2026. Well, it is observed that in the circumstance, the counsel for the respondent refinery is not ready. This court shall proceed with the disposal of the petition. This is pertaining to that case now where he wants to give up the license. What is the matter about? Right? Huh? So they made it 50 bedded now. And 50 bedded there is a bar. So they can't give you the license. So then I'll be there. You see, excise had no problem with money. Excise has no one. Fishery, today in the day, I found the two things. Fishery doesn't have the problem with money. Excise has also no problem with money. Excise department once should give, just for example, in the earlier case, if you had granted her the license or renewed without going into all these things, you would have earned revenue. You are closing a particular shop out there just not to earn revenue. Same here also, they don't want money. So money is not the consideration. They go as per law. So therefore, let us go as per law. How can there be in view of 295? So 295 is the problem. How do you take care of it? They cannot give you the license in that locality. You see, Mr. Counsel, the main problem arises not because of anything else. You are saying that that was never a term of the tender. But whenever the tender is issued, it is always inclusive of the law. And the law is 295, 289. 295 is shifting. No? Complaint. It is 289. You can't help it. No case. Ask your senior to be there to dismiss it in his hands. No, if there is a change in the circumstances post the submission of the bid, post the submission of the bid, if there is a change in the location, earlier there was no problem. But by the time the tender was being processed, a new hospital comes in. At 30 bedded, there is no problem. The moment it became a 50 bedded, it became a problem. So 30 bedded, no problem with that. So therefore, these became 15 to 30 during the process after the bid being submitted. So therefore, why he can't be taken, if he can't, why a representation in that regard cannot be taken for giving an alternative? But this is after the submission of the bid. Understood. I'm not on the financial bit, but my question is after the 15 bedded, 15 bedded became 30 bedded pursuant to he submitting his bid. So there is a change in the situation which had occasion on account of a event which he had neither control, neither you had the control. So why he should not be given an opportunity? Because at that point of time, this situation was not there. You have filed a reply. Because unless that representation is not being considered, you can very well consider the representation on that aspect, provided he provides something before granting. You have not granted till now anybody to somebody. No, there's no stay also. Very difficult, Mr. Counsel. You have missed the bus. Anyways, the counsel appearing on behalf of the petitioner submits that a reply has been filed to the affidavit in opposition filed by the respondent number 3. However, the said reply is not on records. List this matter again on 29th of July 2026. In the meantime, the registry shall bring on record the said reply. That is the problem now. Yes, Mr. Sharma. Eight. Here you ask for both initially. Huh? Now, heard Mr. J. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. D. Gogoi appears on behalf of the Forest Department. The petitioner hearing is agreed by the imposition of an amount of 10% of the 10% of the 10% of what? 10% of the KISS fund, per KISS fund, which is to the tune of rupees 3,44,504 on account of the DMFT fund. The petitioner also in the instant proceedings challenged imposition of 10% of the KISS fund towards the KISS money towards the MMDF fund. In the proceedings before this court on 26/9/2025, the petitioner gave up the claim pertaining to refund of rupees 3,44,509, which was taken by the, which was charged by the respondent department on account of the MMDR fund in view of the judgment of this court in the case of Vishnu Pratim Bora versus State of Assam and others, reported in 2024 1 GLR 216. However, the learned counsel appearing on behalf of the petitioner submitted that there was no authority or jurisdiction upon the respondent authorities to charge an additional 10% of the amount, that is to the tune of rupees 344,504 towards the DMFT fund. And as such, the petitioner was entitled to the refund thereof. Taking into account the above, this court by the order dated 26/9/2025 directed the respondents to bring on record their stand as regards the imposition of the additional amount of 10% to the tune of rupees 3,44,504 on account of the DMFT fund. In pursuance thereto, an affidavit has been filed by the respondent number 3, wherein it is mentioned that the Union of India, by Gazette notification dated 17/9/2015, prescribed a contribution of 10% in addition to the royalty towards a district mineral trust foundation. The state of Assam had also constituted the district mineral trust foundation on 26/8/2016, and further by a Gazette notification dated 3/1/2018, adopted the same rate of 10% towards minor minerals under its purview. This court have also taken note of the notification issued by the Central Government of India, Ministry of Mines, dated 17/9/2015. The constitution of the District Mineral Foundation Trust by the Government of Assam by notification dated 26/8/2016, as well as the notification dated 5/12/2017. 5/12, not? Whereby the Governor of Assam was pleased to prescribe the same rate of contribution to the DMFT by the holder of concessions related to minor minerals as applicable in major minerals. Taking into account the above, it is therefore clear that the imposition upon the petitioner on account of the MMDR fund, as well as for DMFT fund, have been done so with as per authority prescribed in the law. Considering the above, the question therefore does not arise for refunding of the said amounts which have been charged by the respondent department, charged and collected by the respondent department. Considering the above, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. Now what is happening? Now, in view of the order passed in the contempt case, I don't think much remains in this repetition. Huh? We do one thing. We list this matter again in the month of August, along with the contempt application. If the order in the contempt application is complied with, nothing remains in the repetition. And as regards MSME and all, you have to go to the MSME facilitation center. We can't do anything. Because you are disputing it. Are you not disputing? No, no, that you cannot now. I'm not on that. See whether you have disputed the amount or not. This amount of the 18/7/2024 has been released. This court have duly taken note of that there is a direction passed by a learned coordinate bench on 11/5/2026 in con case number, con C number 557/2025. Wherein the respondents, JMC, wherein the various officials of the GMC, including the Commissioner GMC, have been asked to take concrete steps towards compliance to the order dated 9/4/2025. Has the date been fixed? No date. Ah. Accordingly, list this matter on 1/6/2026 with WPC number, with con case number 557/2025 on 1/6/2026. Yeah, file affidavit. Let the affidavit come on record. In the meantime, you want to file a reply? Understood. My question is, he has filed some affidavit. Anybody want to file a reply? Okay. It has been brought to the attention of this court that the TNRD department has filed the affidavit in opposition today in, what is the number? In WPC number 205/2026. Mr. S. Dutta, the Learned Standing Counsel of the PNRD, submits that the said affidavit would be a common affidavit in respect of the other two writ petitions also. Mr. So-and-so, who appears on behalf of the petitioner in WPC number 205/2026, submits that he would like to file a reply. Taking into account the above, list this matter after vacation. On 5th of August 2026, in the meantime, the reply be filed by the petitioner in WPC number 205/2026. Huh? Interim order passed in item number 3, number 2 hetu file. And so would be extended till the next file of interim order case. Oh yes. What happened? Kettle. Mr. Samani, government of Assam is not going to provide you any help. They have already provided you how much money? 10 lakhs, 2023-24, 1 crore in 2024-25, and 37 lakhs in 2025-26. No. They say that we are nothing to pay. They say 12 would not come in. At best, any payment can be made by the State Animal Welfare Board, not They say the claim of the petitioner for rupees so and so up to Iman is not admissible under Rule 12.4 of the Assam Cattle Preservation Rules 2022. The notification dated 23/2/2022 was applicable to the financial year 2022-23. Therefore, the amount claimed before 1/3/2022 and after 31/3/2023 is not admissible in terms with the notification dated so and so read with Rule 4 of the PCA. So they only will give you something from 1/3/2022 to 31/3/2023, isn't it? As per your instruction at number 4, you will consider for the period from 1/3/2022 to 31/3/2023. This is your stand. Kindly come to serial number 4. Read further. Next line. So therefore, as per you, period from 1/3/2022 to 31/3/2023 is admissible, isn't it? Whatever may be, you yourself claim that it is admissible. Now, therefore, huh? I'm not saying that you pay whatever may be. You do one thing. In the meantime, during this period, till the next date, you consider as, as to how much the petitioner would be entitled for that period after scrutinizing whatever materials are. Rest we say that the government of Assam is not bothered with the kettles. Okay. We'll say that the government of Assam is not bothered with kettles. He also admits that we should say. Pursuant to the order passed by this court on 15/5/2026, Mr. J.K. Goswami, the Standing Counsel of the Animal Husbandry and Veterinary Department of the Government of Assam, have stated, upon instruction, that a claim of the petitioner of an amount of rupees 16 crores 16 lakhs 29,460 up to 30/11/2024 is not admissible under Rule 12.4 of the Assam Cattle Preservation Rules 2022. He further submits that in terms of the notification dated 23/2/2022, the amount, if the amount, the petitioner, the Animal Husbandry and Veterinary Department would consider the claims of the petitioner with effect from 1/3/2022 and to 31/3/2023. The learned Standing Counsel also submitted that certain amounts have also been paid to the petitioner. during the financial year 2023-24, 24-25, and 25-26. From a perusal of the instructions so placed, it is the opinion of this court that the Animal Husbandry and Veterinary Department should bring on record the said stand by filing an affidavit. Mr. J.K. Goswami, the standing counsel, submits that the said affidavit will be filed within 3 weeks. In the meantime, this court, taking into account the admitted stand of the Animal Husbandry and Veterinary Department, that the said department would consider claims for the period from 1/3/2022 to 31/3/2023, directs the Director, Animal Husbandry and Veterinary Department of the Government of Assam, to consider the claims of the petitioner for the said period. And in that regard, the representative of the petitioner shall approach the Director, Animal Husbandry and Veterinary Department, would approach the so-and-so on 29th May, along with all details concerning the period from 1/3/2022 till 31/3/2023. It is further directed that on the next date, the Animal Husbandry and Veterinary Department shall give a report as to how much the petitioner would be entitled to upon necessary verification for the period from 1/3/2022 to 31/3/2023. List the matter again on 3rd of August 2026. It makes no sense. They would not do it. Okay, 27th of July 2020. On which date this court shall consider as regards passing of any interim directions on the amount which have been verified. So further to that, the respondents in the Animal Husbandry and Veterinary Department shall file their reply affidavit in opposition on or before 17th of July 2026. Liberty given to the petitioner to submit any reply thereagainst by 24th of July 2026. The instruction so placed by Mr. J.K. Goswami is kept on record and marked with the letter X. Why haven't you filed? Do you think this court passes order just for the sake of it? Then impose a cost of 10,000. 10,000 upon the district commissioner for not filing that. Because of the fact that, you see, you are stopping the progress of the matter. Didn't I make it very clear? No. I'm not there. When we passed that order categorically, during the course of the hearing, it was brought to the attention of this court by Ms. Yudas, the learned additional senior government advocate, that the Deputy Commissioner at Bongaigaon has admitted the claim of the petitioner, and an affidavit in that regard by alia would be essential. In the meantime, the Deputy Commissioner alia is directed to bring on record his stand by filing the affidavit. It is unfortunate the manner in which the District Commissioner Bongaigaon is unfortunate at the triviality at which the District Commissioner Bongaigaon have taken the instant proceedings lightly. This aspect is apparent from the fact that in spite of a direction passed by this court to file the affidavit by the District Commissioner, no such affidavit have been filed. Mr. So-and-so, appearing on behalf of the District Commissioner, submits a final opportunity may be granted to stop. It is the opinion of this court when this court fixes a date for filing the affidavit, the said affidavit not being filed, it derails a proceedings. First of all, the derailing of such proceedings has the effect of interfering with the course of justice. Accordingly, with a stern warning, this court grants a final opportunity to the District Commissioner to file the affidavit. First, list this matter again on 19th of June 2026. An affidavit in that regard be filed, affidavit as directed, while the order dated 22/4/2026 be filed on or before 15th of June 2026. Yes, madam. For what? 9,17,841. Why you are not paying, madam? Whom? There, Joint Director of Health Service does it for everybody. Another official, you have to be very careful. You do one thing. We take her stand saying that the National Health Mission should be made a party, because this was done under the National Health Mission. So we make them a party in view of her submission. Then we bring Mr. M. Bhuya there to accept the notice and then proceed. Ms. So-and-so, who appears on behalf of the Health and Family Welfare Department, submitted that the claims of the petitioner in respect to the work orders would not lie before the Health and Family Welfare Department, inasmuch as these items which were supplied were under the aegis AEGIS of the National Health Mission State, National Health Mission Assam. The Lalit's Standing Council of the Family Health and Family Welfare Department therefore submitted that the the National Health Mission Assam should be made a party in the instant proceedings. Taking into account the above, this court is of the opinion that the interest of justice would be met if the mission director, National Health Mission Assam, is made a party to the instant proceedings. Accordingly, this court includes the state mission director, National Health Mission Assam, having his office at Christian Basti, Gauhati 781005, as the respondent number 4 to the instant application. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days, and the registry shall, on the basis of the present order, as well as the memo of parties, make necessary changes in the cause title and update the same in the CIS. Mr. So-and-so, the Standing Council of the National Health Mission, accepts notice on behalf of the newly impleaded respondent number 4. Extra copy of the said writ petition be served upon him by Monday. List this matter again on 10th of August 2026. In the meantime, the National Health Mission, the respondent number 4, shall apprise this court as to whether the petitioner is entitled to the amount as claimed for. Okay? Everything. Again, National Health Mission. Then it's okay. Huh? What is your stand? Are you denying the work orders? Okay. You verify and pay. Verify and pay within 6 months. Work orders admitted, but verification and all those things will be required. Varnali Das, J Das. Yes, Mr. J Das. I haven't seen you for a long years. Yes, what is your case? Yeah. Hello. You want to file a reply? Mr. J Das, the learning counsel appearing on behalf of the petitioner, submits that the affidavit in opposition has been filed by the respondent number 5. Have you filed affidavit, Mr. B Das? You don't want to file? Huh? Status quo in the? Where? There is no status quo. But what stops you from filing? Reply has been filed. You would file a reply within 3 weeks. Mr. Bidas, appearing on behalf of the APDCL, respond numbers 1 to 4, submits that the APDCL would also file their reply within 3 weeks. List this matter again on 17th of August 2026. In the meantime, the APDCL shall file their reply on or before 7th of August 2026. Liberty given to the petitioner to file reply thereagainst. The petitioner shall also is given the liberty to file the reply against the affidavit filed by the respondent number 5 on or before 10th of August 2026. What is this? Contractual bills? How much? Huh? Why it has not been paid? Oh, where is it? As per the FOC so and so and the budget dated received from the engineer, some payment was made to the contractor on time. However, after making the said payment, no response has been received from the petitioner long end regarding the non-credit payment. Resultingly, it was not feasible and difficult to rectify the same. The GA department has created FS where the credit vendor details was linked. On receipt of the FS so and so, the FOC and the name of the vendor mentioned in here was found correct with the name of the contractor of the VR along with the name of the work, for which the DDO had to release the payment. In this regard, it must mention that the vendor's details could not be verified with the FS because only the name of the vendor was mentioned in the FS. So they paid to somebody else. Ah. Hmm. Where? Ah. Where? 27? No, no, where? 27.3. How much? Then what happened? Okay. Late. You made very late. Did you make the representation very late? Who has made the payment? Now, my question is, whoever have done it, he must have provided his bank account. In the bank account, he has given these details. Therefore, you're transferring it. Why? Whoever had made that mistake, you recover it from that officer. But he can't be stopped. You pay the interest. Because of the fact that you are delaying it, you pay the interest. Huh? You don't have a copy of the petition, but you have the instructions. Anyways, you want to file your reply. Mr. A. Pukon appearing on behalf of the GAD department. The best part is GAD, Mr. B. Gogoi also appears. Mr. M. Bhuya appears. And every time the court changes the counsel, does it make that they don't know? The department knows. Both of you may not know. The same set of counsels. Anyways, Mr. A. Pukon, the learned counsel appearing on behalf of the GAD, submits that 2 weeks' time may be granted to him for filing a reply affidavit in opposition. So taking into account the above, this matter again on 19th of June 2026. In the meantime, 19th, okay. On 19th of June, can you do it? In the meantime, the reply be filed on behalf of the GAD department on or before 17th of June 2026. This court further directs the under whom you worked, GAD or whom. This, this court further directs the PWD department to apprise this court by way of instructions on the next date as to whether the petitioner had provided the bank account wherein the amount was to be credited at the time of submitting the bills, at the time of entering in the contract. When do you provide? Now, did you provide? Huh? Every time you have to give a barrier. Shall also apprise this court that as the petitioner is a registered, that I know, PWD, if you're working 1, B, C, D, E, whatever it may be. I've seen it. Your basic question is in the FS, there was no mention. I'm not on that. That is your mistake. My therefore question is whether the respondent department shall apprise this court by way of instructions as to whether the respondent department had the bank account of the petitioner prior to the release made of the amount of rupees 6,843 in their records. More particularly taking into account that the petitioner is a class 1A contractor. But police, earlier also time has been sought for. How many times? Police case, how much? How will they run the vehicles? Anyways, now the police says that they will be asking, his vehicle is of no use now. Petrol, diesel, no use. They would not be taking up this. If you don't pay, how will you purchase the EV vehicle? If you purchase a vehicle, then only you can hire. This is the recent notification. Then, when are you paying? 2 weeks. Ms. Yuda, the learned additional senior government advocate, submits a final opportunity may be granted to the respondents to bring on record their stand to produce instructions before this court as to whether the petitioner is entitled to the amount so claimed. Pusto. List this matter again on 19th of June 2026. Pusto. The respondents shall place instructions before this court, shall either file an affidavit or place instructions before this court as to whether the amount claimed by the petitioner is duly admitted or not, or as to whether the petitioner is entitled to any amount or not. The petitioner is entitled. Yes, Mr. Bhattacharya. Again fighting against another counterparty. Interim order. They file affidavit. It has been submitted that the IOCL has filed an affidavit today, yesterday. Their colleague did to me. The Mr. S. Bhattacharya, appearing on behalf of the petitioner, submits that the petitioner would like to file a reply. Urgency? No urgency. No urgency. This matter again on 31st of July 2026. In the meantime, reply be filed by the petitioner on or before 29th of July 2026. What? What is the urgency? See, I I'm sitting out here with the field, entire field. June is filled up. There's no place. 23rd is closed. Huh? 23rd June is closed, Vicky. Huh? Why there is no case on 23rd? On 23rd. Not a single case. Oh, 23rd and 26th, no cases. Why? 23rd day. It's empty. Nobody thought about it. Anybody wants date on 23rd and 26th missing? You file your reply by then. Okay. Yes. Non-payment. PHE. What? Which one? 2014 and 2020. Where is the work order of 2020? 49,000. Huh? Total amount is how much? We cannot look into other amounts except 49,000. 2014, 12 years old matter, we are not going to know. Huh? 2020 is 49,000 only. See the work order. Isn't it? Page 24. It's just 49,840. Why haven't you paid that? That's only death instruction. I can't verify the other one. You just produce the instruction. You file an affidavit saying that it is difficult to verify the 2014 matter. It is very difficult, not traceable. It is after such a long time he has come. As regards the other one, come up and verify and say. Mr. R. Gogoi, appearing on behalf of the PHE department, submits that 2 weeks' time may be granted to file an affidavit in opposition to establish this matter again on 29th of July 2026. In the meantime, the affidavit in opposition be filed on or before 20 July 2026. Take that plea. Mr. Bora, what is this? Huh? 15th of June. It's okay. List this matter on 15th of June along with we are not going to file. Okay. What is there to file reply? Okay, list this matter on 15/6/2026 along with WBC number 6479/2025. Ms. So-and-so, who appears on behalf of the Karbi Anglong Autonomous Council, as well as who wants to file? Forest? No. You have filed. You will file. As well as the Forest Department. Mr. R. Gogoi, appearing on behalf of the Forest Department, submits that in the meantime, they will complete their side of the pleadings. There's no urgency. Is a stay order being granted, then also you have not filed. So we have it in the month of December. Okay, you admit that. Mr. R.R. Gogoi, the learned counsel, standing counsel for the Forest Department, submits that the affidavit in opposition has been sent for vetting, and he submits that the same would be filed within 2 weeks' time. To list this matter again on 31st of July 2026. The affidavit in opposition be filed on or before 15th of July 2026. Let me complete. Petitioner granted liberty to refile reply on or before 30th of July 2026. Interim order passed earlier shall continue till the next date. Yes, Mr. Kyle, what has happened now? Huh? Yeah, that I have also mentioned earlier also. It is the same submission, nothing has improved. Because earlier Mr. K. Jain, the legal counsel appearing on behalf of customers, submitted that the application filed by the AR seeking provisional release of the vehicle have been forwarded to the custom authority at Shillong. That is also mentioned. What is new after 1 month? That is a different thing. That is your cause of action against him for issuance of a notice. I'm not concerned. She is against the provisional release. Provisional release, what is happening? There, we are not concerned with what notice you are issuing upon her. My question is, if they don't reply, you know what to do. Then you should have provided an update. It remains the same. Huh? You pay the rent for the vehicle. Where is the representation? And this you have forwarded to that Shillong. Okay. Okay, don't worry. Heard Miss SSG at the Learning Council appearing on behalf of the petitioner, Mr. S.C. Kyle, the Learning Senior Counsel, as well as the Standing Counsel of the Custom Department, assisted by so-and-so appears for the respondents. The petitioners herein have approached this court being aggrieved by the non-consideration of by the seizure of the vehicle bearing registration number NL07AA5366, as well as the non-consideration of the prayer for release, provisional release of the said vehicle. On 29/4/2026, when the matter was listed before this court, it was informed that the said representations were submitted by the petitioner on 27/11/2025 was forwarded to the custom authorities at Shillong. This court, via the said order dated 29/4/2026, directed the respondents to provide an update today. Mr. S.C. Kyle, the Learned Senior Counsel, again repeats the same submission which was made on 29/4/2026 to the effect that the aspect pertaining to the provisional release of the petitioner's vehicle have been forwarded to the customs authority at Shillong, and any decision taken thereupon shall be duly intimated to the petitioner. Till date, under such circumstances, it appears that no steps have been taken by the custom authorities at Shillong for redressal of the petitioner's representation. Considering the above, this court fixes this matter again on 10th of June to 12th of June 2026. In the meantime, this court directs the concerned or custom authorities before whom the representation of the petitioner is pending to decide and dispose of the representation and place a report before this court on the next date so fixed. Failure to do so, this court shall be constrained to pass appropriate directions. Oh, what is this? Huh? You are not filing affidavit. You filed. You? You FCI? FCI takes some time, no? Yeah, who is this lawyer who doesn't appear? Huh? Not serious. Well, I haven't seen him for a long, long time here. Of course. Huh? He was having some, I think, some problem with his back. Anyways, it has been submitted that who has filed the affidavit? 125 has already filed the affidavit in opposition. Mr. B.K. Singh, the Learned Standing Counsel of the FCI, submits that he would be filing the affidavit within 3 weeks. List this matter again on, there's no stay, na? List this matter again on 7th of August 2026. In the meantime, the reply affidavit be filed by the respondent number 66 on or before 22nd of July 2026. The petitioner is also granted liberty to file reply to the affidavit in opposition filed by the respondent numbers 1 to 5 in the meantime. Yes, what is this? What is this matter about? What? You have not paid the establishment charge? How can it be operational, non-operational? No. How is it possible? Establishment charge was at that point of time, prior to the coming into effect of this act rules. So establishment charge at that point of time, because there was a requirement of having some persons there for the purpose of looking into it, because in view of the change in the nomenclature of the bonded warehouse with that of the wholesale warehouse? No case. No case. No case. No. You have made the payment. Oh, anyway, they don't want man. Huh? For what? Implement for what? But is there stay? Okay, okay, very good. Then it's okay. No problem. Matter of processing of the license provision is made subject to further orders to be passed. What is this IA for? Why? Okay, this is an application filed for including the Commissioner of Excise as the respondent number 5 to the accompanying writ petition. Mr. R.R. Gogoi appears on behalf of the respondent numbers 1, 2, 3. Gustav. Take 1, 2, 3, and 4 also. Understood, but these are all under you, na? For the, when it comes to excise. 1, 2, 3, 4. Gustav. Taking into account that the presence of the Commissioner of Excise is essential for the purpose of for a effective adjudication of the accompanying petition, this court includes the Commissioner of Excise, Assam, having his office at Housefed Complex, Dispur, Gauhati 781006, as the respondent number 5 to the accompanying writ petition. First of the counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days, and the registry on the basis of the said memo of parties and the order passed by this court in the instant application make necessary changes in the accompanying in the cause title of the accompanying writ petition and update the same in the CIS. I stands disposed. Mr. R. Gogoi appears on behalf of R.R. Gogoi appears on behalf of the newly included respondent number 5. He therefore submits that the adjoined affidavit would be extra copy of the writ petition be served upon Mr. Mr. R.R. Gogoi by Monday. It is also being Mr. R.R. Gogoi, the learned standing counsel of the Excise Department, submits that the affidavit on behalf of the respondent numbers 1 to 5 shall be filed within 3 weeks. List this matter again on on 5th of August 2026. In the meantime, the affidavit in opposition be filed on or before 27th of July, 22nd of July 2026. Liberty given to the petitioner to file reply therein. Infructuous? Not infructuous? I've in fact quoted it. Then what is wrong with it? You get your instruction, otherwise we pass the order. No affidavit has been filed by the respondents in spite of notice having been issued on 22/5/2026. Taking into account that the petitioner has been debarred and there is a requirement for and the matter in issue is covered by the judgment of this court in the case of Nestor Pharmaceuticals Limited versus State of Assam, reported in 2025 SCC Online GAU 5168, comma. This court fixes the instant writ petition for final disposal on 9th of June 2026. In the meantime, the respondents herein shall consider, is given the liberty to consider, is directed to reconsider, is given the liberty to reconsider the impugned order dated 14/11/2025 in terms with the judgment of this court in the case of Nestor Pharmaceuticals Limited and another Supra. What is this? Amicably settled. Huh? So, oh, you just offered and that is what you said. I never said 5CCL. I was a bit surprised. Huh. There's no discussion. Then how did one arrive at the amount? No, Mr. Das admitting would not do. It has to be admitted by that person concerned. Huh? No, we dismiss your petition. No, we dismiss today. Heard, Mr. Heard, Mr. KC SC Kyle, the learned counsel, senior counsel, appearing on behalf of the petitioner, assisted by so and so. Mr. S. Das, the learned counsel, appears on behalf of the respondent. Number respondent number 2. Ms. Udas appears on behalf of the respondent number 1. The present application has been the present petition has been filed by the petitioner challenging the award dated 30/9/2022, passed in reference case number 8/2008, whereby there was a direction for reinstatement into the services of the management in the same cadre with which the respondent number 2 was holding before her removal, along with 60% back wages, except the period of her absence. In addition to that, it was also mentioned that the respondent number 2 would be entitled to an amount of rupees 20,000 as litigation cost. First, on 19/5/2026, it was submitted by the parties before this court that the matter was amicably settled. However, today, Mr. S. Das, the learned counsel, appearing on behalf of the respondent number 2, submitted that there was no such settlement, inasmuch as without any information, inasmuch as the respondent number 2 was never informed prior to making the submission before this court on the last date. Considering the above, this court is of the opinion that the matter requires to be disposed of Considering the above, as the matter cannot be amicably settled, this court is of the opinion that a matter requires to be disposed of on merits. Further to that, the reference case, the industrial dispute in question have been pending for the last for the last 18 years. And as such, the matter requires an urgent disposal. In that view of the matter, list this matter on 11th of June 2026 at the top of the list for final disposal. Mr. Das will allow your petition. Dismiss the petition. Allow you. You are. Huh? You're asking for disbursing. Miss P. Chakraborty, the Standing Counsel of the Water Resource Department. Water Resource, na? Water Resource Department submits that 15 times time is required for disbursing the amount of rupees 4,82,214 after necessary deduction. There will be some deduction, huh? After necessary statutory deductions to the petitioner. So taking the above, list this matter on 19th of June 2026 for an update. Yes, Mr. Dutta. Huh? What is the insufficient document? Whose bid was higher? So there was more compliance. Yes, Mr. Counsel. You put it on affidavit. Put it on affidavit, that is. And the resolution which is there, put the translated copy on. I think that will be better. Because obviously, huh? And anyway, the period is ending on 36. Okay. Okay, how much time will you? The records, the instructions have been placed before this court. Now, Mr. S. Dr. submits that he has been placed, given the records, and from the records it is seen that none of the bidders had submitted all the documents required. However, the compliance by the respondent, private respondent, number 8 was more, in as much as the private respondent number 8 submitted 8 documents, 8 documents, whereas the petitioner submitted 6. It was also mentioned that both the petitioner as well as the respondent number 8 had submitted, had placed the same bid. And under such circumstances, the respondent number 8 was granted the settlement. It is the opinion of this court that the said aspect be brought on record by filing an affidavit. Mr. S. Dotto submits that the said affidavit would be filed on or before, on or before 3rd of June. List this matter again on 5th of June 2026.